So we'll go to Senator Cramer.
Thank you. Thank you, Chair Capito and Ranking Member Whitehouse. Congratulations to both of you for assuming these important leadership roles, and congratulations to you as well. My former colleague in the House, Mr. Zeldin, thanks for stepping in the gap and taking on this big challenge. I know that Chair Capito has already talked a little bit about what is a really, really important issue for me, and I think for a lot of us, obviously, and that is an appropriate cooperative federalism role between the state and federal governments. And there's a lot of opportunity to do that the right way, and a lot of opportunity to do it the wrong way at the EPA. So I'm going to point to one specific case that I think you're probably familiar with, and that's, of course, the waters of the United States. And you're no doubt aware of that legal, what I call fiasco, surrounding the definition of what constitutes waters of the United States. This has been litigation ping pong for a long time. And so the first question is a simple one, Mr. Zeldin. When you read the Sackett decision authored by Justice Alito, would you describe it as prescriptive or ambiguous as it comes to the definition of a federally jurisdictional water?
It was clear and prescriptive.
It was. When the decision was issued, the Biden administration officials even told me that the direction from the Supreme Court was clear, that they didn't leave a lot of ambiguity. And here's one portion that I wanted to chat with you about, because I believe it's particularly instructive should you be confirmed. Quote, "Finally, it is also instructive that the Clean Water Act expressly protects the primary responsibility and rights of states to prevent, reduce, and eliminate pollution, and to plan the development and use of land and water resources. It is hard to see how the state's role in regulating water resources would remain primary if the EPA had jurisdiction over anything defined by the presence of water," unquote. Now, I was tempted to bring the poster, but in previous definitions, as they've gone back and forth, there's one that Sackett was based on, actually, or that would be relevant to Sackett, where the entire state of North Dakota was basically a federal wetland. We're a semi-arid state with badlands and big prairies. Should you be confirmed, it would be really good if the administrator took this decision and the legislative history behind it and start a rulemaking process post-Sackett with the assumption that states have primacy and primary responsibility for water within their states, not the federal government. How do you intend to sort of approach that? Because this post-Sackett WOTUS definition is going to be really, really important.
Yes, Senator. With any rulemaking, as you know, I'm not allowed to prejudge outcomes going in. And it's important that corners aren't cut where durability is sacrificed. Laws are written by Congress, and there are cases that have come out from the Supreme Court that provide the EPA with clear guidance on how we must do our job under the law. It is important that when you're going back to your home state and you're speaking to your farmers, that you are able to, with confidence, be able to explain to them that the federal government is doing our part so that they can define what waters of the U.S. are without them having to go hire an attorney or someone else, pay a lot of money to ensure compliance. So I will make sure that I'm doing my part, that the EPA is honoring the decision of Sackett and any future laws to come out of Congress. That is my commitment to you. And I know that was important when I met with Senator Sullivan as he was speaking about Alaska and wetlands and so many other people on this committee. So I look forward to working with you on that.
That great answer. I appreciate that very much. One of the things that concerns me is when I've heard, in realizing, with regard to WOTUS, you have two agencies that get involved, the permitting side at the Corps of Engineers and the EPA rulemaking. But one of the things in terms of a durable rule that I heard from some from the previous administration or the current administration was that, well, we're going to create a durable rule, and I think the way to do that is to make sure that while we recognize that the law is clear now, the definition's clear, all you have to do is seek a jurisdictional determination from us, the Almighty, and then we'll tell you whether your land meets that definition or not. To which I say, you don't put a police officer on every car. Can we presume that in the very obvious, simple cases that the landowner or the developer already knows the law and doesn't need to seek permission to do what they want to do?
Unfortunately, we face a reality where many farmers don't know whether or not their land, not just farmers, obviously, but a lot of people don't know whether or not their land has waters of the U.S. on it. And I would say that that is a failure on the part of the federal government. You should be able to go to your landowners, and they should be able to, with confidence, be able to tell you without having to ask questions whether or not waters of the U.S. are on their property.
Well, thank you for that. I can tell you North Dakota farmers are pretty bright. They know, it's just that the bureaucrats didn't. And now hopefully the Supreme Court's cleared that up. Thank you.